In preparing this conference, we aim to address as many of the relevant issues and subject areas as can be imagined for something as broad as impending conflict with Iraq. And the starting point for all of this, at least in some of our minds, was the legal issues. We're very fortunate today to have two of BYU Law School's greatest law professors, Professor Brett Scharffs and Professor Richard Wilkins. There actually are programs that are being printed right now, so let me indulge you with a few relevant details that will impress you even further about these two professors. Professor Brett Scharffs is a professor of law at the J. Reuben Clark School of Law. He received his BSBA magna cum laude and MA summa cum laude from Georgetown University, Bachelor of Philosophy as a Rhodes Scholar at Oxford University, and a JD from Yale University, where he graduated with university honors and was senior editor of the Yale Law Journal. He practiced law with Sullivan and Cromwell in Washington, D.C., and was a judicial clerk with Judge David Sentil, U.S. Court of Appeals for the D.C. Circuit, legal assistant for Judge George Aldrich of the Iran-U.S. Claims Tribunal in The Hague, and Professor Scharffs teaches courses in international securities, regulation, church and state in the United States. As you can see, Professor Scharffs is well prepared to address the international legal issues that we will be talking about today, and specifically those pertaining to the Security Council resolution. Secondly, Professor Richard G. Wilkins, also professor of law at Brigham Young University and director of the World Family Policy Center. Professor Wilkins has written numerous articles on constitutional issues and conducts an annual survey of Supreme Court voting trends published by Hastings Constitutional Law Quarterly. He's the former assistant to the Solicitor General of the United States Department of Justice, is married to Melanie Moore Wilkins, and father of 4 children. He is not going through a rebellious stage, but is growing out his sideburns for his upcoming debut.
It's hardly debut.
21st?
No, 18th.
Year as Ebenezer Scrooge at the Salt Lake Hale Center Theater, which I can say is quite a production. So, Professor Wilkins teaches courses on con law as well as international organizations. So we're very grateful to welcome these two distinguished scholars. The format for today will be very informal. We'll invite our panelists to make brief comments and then respond perhaps to one another if they desire, and then we'll open up to the floor for questions. We also are webcasting this conference, aware that many people who might be interested are not here or could not make it to a particular session, and we're also archiving digitally these sessions. The little bubbles you see on the back walls look like security cameras, and they are recording the proceedings. So we ask that if after the panelists have made their initial remarks, you would like to ask a question, raise your hand and we'll get a portable mic to you so that we can record your question as well for the audience in absentia. Professor Scharffs.
Corey, thank you. And we both, and speaking for myself, appreciate very much the opportunity and invitation to be here today. Today I'm going to be talking a little bit about terrorism and the rule of law, and in particular the United Nations response and role in preparing for a possible military response to the situation in Iraq. During times of tension and fear such as these, with the memories of September 11, 2001 still vivid in our collective memories, our commitment to the rule of law is severely tested. During the past year, events have occasioned a serious discussion in the United States and elsewhere about how to balance important rights and basic freedoms such as liberty, privacy, and due process with other very important issues such as security and safety. Terrorism poses a particular threat to the notion of government under law because it demonstrates no commitment to the rule of law, but rather operates furtively from the shadows. Thus, in the ways we respond to terrorism, we will learn much about how deep and real is our commitment to ideals and ideas such as the rule of law. The questions I have been asked to address this morning center around the lawfulness of a possible attack on Iraq by the United States, either alone or together with what President Bush yesterday called a coalition of the willing. Issues of legality and illegality are often more complex than they appear. This is particularly true when questions of war are at stake, and especially when the anticipated action is preemptive in nature rather than in direct response to an attack on one's own soil. There is no longer serious doubt that there is such a thing as international law, but its content, force, and status remains very much disputed. In a world dominated by a single superpower, and in particular when that superpower is the United States, the argument that might makes right has a certain appeal. But as a principle of lawfulness, such a principle is severely flawed, if for no other reason than that one can never assume that one's position of hegemony will be permanent. Indeed, history teaches that a world dominated by a single superpower is the exception rather than the rule. In all legal systems, there are hierarchies of authority. Some sources of law have a greater claim to legitimacy than others. In American law, the Constitution is at the top of the hierarchy, with federal laws and treaties below the Constitution and administrative and state law below that. A hierarchy exists in international law as well. In general, binding multilateral treaties have the greatest force, followed by other types of treaties and widely embraced principles of customary international law. Actions by the United Nations, such as the General Assembly resolutions, are generally not viewed as representing binding international law, but they do claim a place in the hierarchy of sources of authority that have some claim to legal status. Because of the very different nature of international law from the law of states, most especially the absence of a centralized enforcement mechanism and effective judicial system, it is especially important to think of lawfulness and legality as occurring across a spectrum rather than appearing as distinct categories of lawful and unlawful. Answering the question of whether some particular action is legal or illegal under international law often requires an answer that is less than precise. Questions often are focused on issues of credibility and legitimacy rather than a straightforward assessment of legality. In my opinion, it is helpful to think of international law as occupying a sort of tenuous middle ground between military might and political power. It is often said that war is extension of politics by other means, and that military force is just a particularly effective means of persuasion. International law, however, can mediate between politics and war. It places limit on what will count as legitimate political maneuvering and what will be acceptable behavior in times of war. I want to talk a little bit in particular about the United Nations and the Security Council in particular. Security Council resolutions have a very strong claim to high status as a source of international law. Under the UN Charter, the Security Council has primary responsibility for the maintenance of international peace and security. The Security Council has 15 members, 5 permanent members, China, France, Russia, the United Kingdom, and the United States, and 10 others that are elected by the General Assembly for 2-year terms. Each member has 1 vote, and on procedural matters, 9 out of 15 is considered a majority. On substantive matters, the same rule applies, but the 5 permanent members each have what amounts to a veto. The veto rendered the Security Council largely ineffective during the Cold War, since both the United States and Russia, and also China for that matter, had the veto. Since 1990, there has been great hope that perhaps the Security Council would become a much more important and effective mechanism for addressing international security issues. To a large extent, this hope has yet to be realized, although the use of vetoes since 1990 has become much less frequent. One of the reasons that the Security Council resolutions have greater claim to legal legitimacy is that under the Charter of the United Nations, all members agree to accept and carry out the decisions of the Security Council. The Security Council is unique in this respect. Other UN organs can make recommendations to governments, but the Security Council has the power to make decisions that member states are obligated under the Charter to carry out. In particular, when a series of Security Council resolutions exist, the claim to legal legitimacy is enhanced. In the late summer and early fall of this year, there was a serious debate within the United States political establishment about whether the United States should go to the United Nations to garner political and legal support for a possible invasion of Iraq. There was a parallel debate about separation of powers within the United States. The domestic question was whether the President had the authority to go to war with Iraq by himself, or whether congressional authorization was first required. This is the topic that Professor Wilkins will address in just a minute. After initially indicating that he did not need congressional authorization, President Bush decided to seek congressional resolutions in support of the use of force against Iraq, perhaps for political rather than strictly legal reasons. In any event, by the time President Bush had received strong congressional support for a resolution authorizing the use of force in Iraq if necessary, this was widely viewed as giving him a strong tactical advantage as he took his case to the United Nations to seek to forge an international consensus against Iraq. The debate about whether to adopt a strategy that utilized the United Nations or not was the latest installment of an ongoing debate between unilateralism and multilateralism. It's easy to be romantic about multilateralism. We may think that it's always good to act together and always bad to act alone. But, of course, the reality is more complicated. Don't act alone often really means don't act at all. And a high-minded sounding commitment to multilateralism can often act as a justification, pretext, or excuse for doing nothing. On the other hand, certain risks are heightened when a unilateral strategy is followed. Writing in the New York Times, former Secretary of State James Baker said in defense of President Bush's decision to take the UN route, winning the support of the Security Council would go a long way toward reducing the potential political, economic, and foreign policy costs of this difficult but certainly justified undertaking. It may be worth noting that in his defense of multilateralism, Mr. Baker did not invoke enhanced legal legitimacy as an important justification for multilateralism. In September, President Bush spoke to the United Nations, making the case for urgent and forceful action to end Iraq's defiance of international law and to challenge the United Nations to make meaningful the idea of multilateralism. Instead of giving a speech to justify unilateral, preemptive U.S. action, as many expected, Bush made a very different argument, that the integrity and credibility of the United Nations rests upon its ability to take action in confronting Saddam Hussein. President Bush said, Saddam Hussein's regime is a grave and gathering danger. To suggest otherwise is to hope against the evidence. President Bush noted that in response to Security Council resolutions, indeed about 10 Security Council resolutions since 1991, the Iraq regime agreed to destroy and stop developing all weapons of mass destruction and long-range missiles, and to prove to the world it has done so by complying with rigorous inspections. Iraq has broken every aspect of this fundamental pledge. As one political analyst described it, the President, in effect, was asking, if not now, when? If not in Iraq, where? If the Security Council will not meet the obligations it has willingly assumed in this unique modern case of aggressive and murderous behavior by a member state, it clearly will never act to enforce its writ and to secure human justice. By calling on the United Nations to rise to the challenge of responding with an effective multilateralism, Bush was implicitly making the case for a more unilateralist approach if the United Nations proves incapable of meeting the challenge. The result was Security Council Resolution 1441, passed unanimously on November 8, 2002. The Washington Post editorialized that getting the Security Council vote required 8 weeks of excruciating negotiations, ably executed by Secretary of State Colin Powell, and also a series of American concessions. Powell was even on the phone with the French foreign minister minutes before walking his daughter down the aisle at her wedding. Even after Security Council Resolution 1441 was passed, President Bush has continued to warn that in the event that Iraq violates Resolution 1441, and to the extent that this results in a Security Council stalemate, the United States will act without United Nations sanction. And this may prove necessary, as it did in 1999 when the United Nations turned to NATO rather than the United Nations to respond in Kosovo. Well, What are the key terms of Resolution 1441? And the most important question on people's mind seems to be whether it obliges the United States to return to the United Nations for further authorization in the event of a violation of the resolution by Iraq. There are several requirements in Resolution 1441. First, the Security Council states that Iraq is in violation of previous Security Council resolutions, particularly Resolution 687 from 1991, which required the cooperation of Iraq with military inspections. Second, it affords Iraq a final opportunity to comply with its disarmament obligations. Third, there is an obligation to provide within 30 days, which will be December 8th, a current, accurate, full, and complete declaration of all aspects of its programs to develop chemical, biological, nuclear weapons, and ballistic missiles and other delivery systems. Section 4 states that a failure in this report or any omissions in this report will constitute a further material breach of Iraq's obligations and will be reported immediately to the Security Council. Section 5 requires Iraq to provide immediate, unimpeded, unconditional, and unrestricted access to all facilities. This is a major change because previously Iraq had limited access in so-called presidential sites. This included, I think, about 8 very significant sites that had something over 1,000 buildings included on those sites. There is no different treatment for presidential sites. Section 8 requires that Iraq shall not threaten hostile acts directed under any representative or personnel of the United Nations or any member state taking action to uphold Council resolutions. And there's been a skirmish about the meaning of this with the recent military action in the no-fly zones, which has been taking place over the last few days. Section 9 gives Iraq 7 days to confirm its intention to comply with the resolution, and Iraq did this. And Section 11 directs inspectors to report immediately any failure by Iraq to comply with the inspection obligations. Section 12 calls for the Security Council to convene immediately upon a receipt of a report that Iraq is not in compliance with the resolution. And Section 13 warns Iraq of serious consequences if it continues to violate its obligations. Well, in terms of clarity, this resolution is generally regarded as a relatively tough program of inspections. The United States, however, did make some important concessions. For example, the language calling for serious consequences was a modification of the United States request that severest consequences be invoked if there's a material breach of the resolution. In addition, after intensive negotiation, a provision calling for the automatic use of force in the event of a material breach was withdrawn. The Washington Post said that Bush was forced to agree to discuss any violations by Iraq with the Security Council rather than moving automatically to military action. The United States, however, has taken the position that the United States does not need further UN approval for an attack if Iraq does not comply with the terms of the resolution. Secretary of State Powell has said that if the Security Council is unable to agree on a second resolution authorizing the use of force, the United States would not be restrained in its response. Powell said, "I can assure that if he doesn't comply this time, we'll ask the UN to give authorization for all necessary means. And if the UN is not willing to do that, the United States, with like-minded nations, will go and disarm him forcefully." The White House Chief of Staff Andrew Card has said, "The UN can meet and discuss, but we don't need their permission." And I think this is basically an accurate description of the compromise which was reached, that the United States has agreed that there will be an immediate meeting of the Security Council, and then, in effect, President Bush will have thrown down the gauntlet that he presented in his speech to the United Nations General Assembly to see whether or not the United Nations would respond with effective multilateralism. The New York Times article quotes an anonymous former U.S. senator as saying that the resolution amounts to a mousetrap designed to provoke Hussein into a destructive act of self-defiance, If there are substantial omissions from his inventory of weapons programs, this will provide the United States with grounds for war. And there is a strong feeling held by many that the inspections regime is going to be very humiliating for Hussein, especially the unlimited inspections at the presidential site. This could signal a loss of faith that could embolden his opponents in a regime that is really ruled primarily by fear and terror. As one commentator put it, a dictator whose rule is premised on the idea of fearsome, unlimited power has to contend with the spectacle of being forced to open his front door at any hour of the night and allow his home to be searched by an unprepossessing, bespectacled 74-year-old Swedish diplomat and his team of arms inspectors. Iraqis could start getting ideas. It's very likely, however, that Hussein will continue to do what he has done in the past, which is engage in a strategy of ambiguity and delay. There is almost no chance that Hussein will comply with the Security Council resolutions. He has tenaciously endured 7 years of UN inspections during the 1990s without ever accepting the principle, much less the practice, of disarmament. And it is quite likely that he would rather die now than to do so. Most likely he will try to play the system, appearing to cooperate long enough to survive the coming winter, the most propitious time for a U.S.-led invasion. He will hope that the inspection team, led by the Swedish diplomat Hans Blix, will not aggressively employ the powers granted under the new resolution. Mr. Blix has already indicated such hesitation, expressing a desire to be fair and careful in his inspections. If Blix is challenged, he will count on cover from the French and Russian governments, which did their best to weaken the United Nations resolution and can be expected to filibuster any U.S. effort at enforcement. Perhaps I will leave it there and turn the time to Professor Wilkins.
Thanks, Professor Scharffs. It is my great pleasure to be here today, and I need to thank Corey and Professor Hudson. It's very nice of you to ask me. And although I've never done anything nearly of the magnitude of Colin Powell, I do like the anecdote about being on the phone before his daughter's wedding. I'm going to pull that one out for my wife the next time my supposedly secret cell phone number rings in the middle of family prayer. I'm going to address for you today what is, by contrast, a fairly mundane issue, and that is the constitutional question of when the United States can exercise its war powers. Now, I state that by contrast it's fairly mundane because although it's complex, but let me assure you it's not nearly as complex as the international question and whether or not we should or must have some sort of international authorization before going to war. Until 6 years ago, when I got involved with international issues, I was just a constitutional law professor, and I thought this was the beginning and end of the world. And I've learned over the last 6 years that it's not. But it is, however, a context that raises many of the same issues that Professor Scharff has addressed. In the constitutional context of the United States, when and how we declare war raises questions about the assertions of power versus the practical realities and the practical politics of waging war, differences between constitutional theories and between everyday realities out there in the land of politics, armies, and citizen opinion. Let me first give you what the constitutional structure is. Article 1, Section 8 grants to Congress the power to define offenses against the law of nations, to declare war, to raise and support an army, and Article 2, Section 2 gives the Senate the right to ratify treaties. Now, not all of these powers have been given adequate emphasis, I think, by the Legal Academy and by cases. In particular, Congress's power to define offenses against the law of nations has been an aspect of congressional power that has been largely ignored because we have assumed that that's a job for the courts. I think very wisely, the drafters of the American Constitution stated quite clearly, in language we have simply ignored to this point, that it's up to Congress to define offenses against the law of nations. And I think once you look at that and combine it with Congress's power to declare war, to raise and support the Army, and the Senate's power to ratify treaties, you can argue that the legislative branch of the United States government has a much broader role in international affairs than we have tended to allow the legislative branch, at least in recent history. If you go to cases and treatises on international law, you will find almost a uniform conclusion that the vast bulk of international power resides with the President. I just raise a minor caution, and I'm not sure it's really even a dissenting voice, but a caution that the clear language of the Constitution does not invest the President with all, nearly all, or anything close to full power regarding international affairs. And that, again, is where I would emphasize the congressional power to define offenses against the law of nations. But the President does have fairly substantial power over international affairs, and in particular with war, because Article 2 provides that he is Commander-in-Chief of the Army and the Navy, he's the Chief Executive Officer, he appoints ambassadors for the United States, and he receives ambassadors and ministers from other nations. It's on these clauses of the Constitution that supporters of the President argue, and I think until quite recently the vast bulk of legal literature has supported the assertion that the President has primary power in areas of international affairs and international relations. Now, why did the framers divide the power up in this kind of messy way? Certainly not to promote efficiency. It's quite clear from the debates surrounding the drafting of the Constitution of 1889 that the drafters did not want efficiency here or in any other part of the Constitution. The argument for efficiency is a modern one. You know, we always hear it all the time. Congress has got to do this. We've got to have a uniform rule because we have to have one rule because it's more efficient. Leaving things up to 50 states is just too bothersome. Well, and that wasn't the view back in 1889 with regard to commerce issues or any other issue, and particularly with the war power. And if you look at the debate, it's quite clear that Congress intended the President to act only when there was an authorization of some sort from the legislature. However, despite, I think, what is relatively clear in the text of the Constitution and in the debates surrounding the drafting and adoption of the Constitution, practical experience stepped in and changed things a little bit. And that's my second point. I've just laid out the theory for you, and then we get to the practical realities. The practical realities are that this separation of powers concept, which was embodied in the Constitution, proved almost immediately unworkable and unpracticable. Every president since George Washington has found it, well, I don't know if I can say every, but everyone I've looked at closely, and I'm not aware of any president that hasn't had to use some force in some even little pipsqueaky affair, like Grenada with President Reuben. Every president, to my knowledge, and again I'm not asserting it's perfect, found it necessary to use military force without congressional pre-authorization. Some of the most outstanding examples are Abraham Lincoln's actions at the beginning of the Civil War, George Washington's reactions to French and English incursions during the early years of the nation, and I could go on and on. As a result, there grew up a vast power of practical, or a vast reservoir of practical power in the president to declare war. Now, to declare war, to decide when to use force and use that force, essentially without extensive congressional oversight. These actions were often subsumed under a supposed exception to the constitutional language, which was that, well, when the president or when the United States is attacked or when there is a serious emergency, we have to assume that the president has the power to act. But this assumption got to be very broad indeed, because you had President Kennedy and President Johnson introducing ground forces into Vietnam, which soon expanded into a very wide large war. It was the war of my generation. It's the war in which many of my high school friends died. And it became a matter of great debate during the 1970s, late 60s and early 70s. There were over 20 cases filed during this period by various citizens, senators, members of the military, etc., seeking a declaration from the United States Supreme Court that it was unconstitutional for the president to wage war without congressional authorization. Now, about all that can be said about these cases is that the court dodged every single one of them on one ground or another. The Supreme Court, I mean. As did most of the lower courts. They didn't get very far. They were mostly dismissed on the pleadings on various grounds. When you look at these cases and look at them together, I think what they stand for is another practical reality. When we're in the middle of military conflagration, the judicial branch isn't going to step in and start ordering the president about or start declaring this or that war unconstitutional. I think, and as I'll point out in a few minutes, I think it's similarly, or it's likewise, that Congress, once we're in the middle of some sort of military action, probably is not going to be very anxious about coming in and ordering a withdrawal of forces either, for the same kinds of reasons. It's just, as a practicable matter, too difficult to order withdrawal. But nevertheless, in the middle of the Vietnam controversy, there was such unhappiness with this reality that had developed over time that despite the language of the Constitution, it was the president's decision not only to be commander-in-chief but to wage war, that Congress passed in 1973 the War Powers Act. Now, the War Powers Act purports to be simply a reassertion of the structure set out in the Constitution. And in fact, the last section, Section 8, says on interpretation of the Joint Resolution, says specifically, we don't mean to do anything other than set out a framework whereby the express language of the Constitution can be implemented. One little footnote here. There's lots of things, lots of debatable issues around the War Powers Act. One of the first ones you encounter is whether or not Congress even has the power to set out a so-called framework statute for interpreting the Constitution. In the only other context that I'm aware of where Congress has tried to do this, the Supreme Court struck it down as unconstitutional. In the City of Bernie case, the Senate, and the House and the Senate set out what they called a framework statute to decide issues of religious liberty. They didn't, the Senate and the House were smart enough to know they couldn't just outright reverse the Supreme Court decision, which had encroached upon religious liberty. So they set out a framework statute saying, here's how you address free exercise claims. But the Supreme Court would have none of it. The Supreme Court said in Bernie, it's our job to interpret the Constitution. Congress, you have no business attempting to interpret the Constitution. The statute's unconstitutional, so there. Now, I thought the decision in Bernie was a little broad and a little too bold for the court, but I'm not a fan of what I consider an imperial judiciary. And I think we ought to have room for all three branches of the government to interpret the Constitution. So I'm not that fond of the Bernie case on many levels. But I think if you were to apply Bernie here, you would get the same result. Congress has no business telling the Supreme Court what the powers of the President and the Congress are regarding declaration of war. There are other troublesome or purportedly troublesome provisions in the War Powers Act as well. Section 3 requires consultation between the President and the Congress. And critics of the Act argue that there's no power. Congress has no power to force the President to come before him or to force consultation. And I think as a matter of strict constitutional interpretation, there may be something to that argument. Section 4 requires a fairly complex reporting scheme. If there's not prior congressional authorization, the President has to submit a report within 48 hours of introduction of forces, and he has to submit a report every 60 days thereafter. under Section 5, if Congress at any time disapproves the President of a particular assertion of power, the President must withdraw forces within 60 days. Now, this is a reassertion of power. Its constitutionality, I think, really depends upon whose side you're on. This is one of those issues where you can go to the literature and find it almost evenly divided. I find myself smack dab in the middle. I'm not sure who's right here. And that means, that's usually where I find myself, is somewhere in the middle of most constitutional questions. That's why I managed to make both conservatives and liberals angry at me. That's why I always am ducking for cover from both sides on most issues. And it's just not very fun. You really ought to learn in today's world to be a partisan of one side or the other just for personal peace. If you're on Congress's side wholeheartedly, as I think maybe a simple majority of the legal academy is, you argue that the clear text of the Constitution says Congress has the power to wage war. Without it, the President can't be Commander-in-Chief. And as evidence that is, I think, the simple majority view of the legal academy, I would cite you to the brief in Dellums versus Bush, which was filed back in 91, when the first President Bush was going about attacking Iraq for the first time, and Professor Dellums, along with the most luminous lights in the legal academy, filed this brief in the D.C. court arguing that the President didn't have power to do this. However, if you go to the literature, you will find a whole host of scholars, and again, nearly as many, arguing that it's a violation of congressional authority for Congress to assert the power the way it has. One of the principal objections is that Section 8, or Section 5, which requires the withdrawal of forces anytime Congress disapproves, amounts to a legislative veto of presidential action, which is unconstitutional under the case of Chadha versus Immigration and Naturalization Services. Now, I have to tell you, just as a scholar standing back and looking at both lines of cases, both the constitutional text and all of the cases from Chadha through Bernie and all of the various cases that apply here, I have to tell you that in my opinion, none of them are applicable fully to the facts of the War Powers Resolution. It's not precisely a one-house veto. It's a concurrent resolution, and it's not precisely an area left solely to executive discretion, as was the case in Chadha when you're talking about assertions of war powers. This is one of those debates that I think you could reasonably come out either way. But I really think the final analysis, and you may wonder why I've then gone on for 15 minutes or so on this issue, at the end of the day, and my bottom line is, I don't think it matters very much anymore, nor will it matter much in the future. I think as a practical matter, the War Powers Resolution has achieved the result that the founders intended. The purpose of the division of powers in the original language of the Constitution was, I think, to require joint action, to require some sort of consultation and working together before the United States committed forces. Back in 91, President Bush, the first President Bush, ultimately found it necessary to go to Congress and get authorization before he attacked Iraq. Current President Bush has found it necessary to go to Congress, and he has in fact obtained a joint resolution authorizing the use of force on Iraq this time. Now, is it strictly constitutionally necessary? Maybe, maybe not. I'm not sure. As a matter of practical reality, is it necessary? And there I think the answer is yes. We simply cannot work in the United States anymore on the notion that the President has unlimited authority in an area where we're going to ask our young men and women to go and give their lives. We simply don't live in that kind of a world anymore. And without the support of Congress, I think it would be very difficult domestically to wage any effective war against Iraq. And I think the same thing can be said on the international front, that without international consultations, it would be very difficult internationally to wage an effective war. So bottom line on the War Powers Resolution for me is it raises a host of interesting theoretical problems. You could take any one of a number of views on these theoretical problems and write a tenure-track paper that depending on whether you were with Professor Dellums or with Professor Corey sent me a thing that he wrote on the email, Professor Holzer. I don't know whether he was a professor actually, but it was printed just within the last month or so. A rather vituperative piece arguing that the War Powers Act is clearly unconstitutional because it clearly invades the powers of the president. So, you could write a tenure-track piece either way. But as a matter of practical reality, I think it does not matter much, because in the new world that was ushered in with the fall of the communist regime, and because, I think in part because we are now the superpower, practical political realities demand that the United States act only when there is the concurrent executive and political will to do so. And so the bottom line is that, at least for now and for the foreseeable future, I doubt that you're going to see any real challenges to the War Powers Act. And in practical reality, it probably has served the purpose that the drafters of the Constitution had in mind when they separated the war powers to begin with. Thanks.
Professor Scharffs, would you like to make any additional comments? Or we open the floor to questions?
We can just open the floor to questions.
Okay. Any questions from the audience? We have a roving mic, if you'd mind speaking into that so we can record your question and everyone can hear.
My question to Greg, at the end of your speech, you talked about what is expected from Saddam to delay or to get into some kind of delaying tactics. And there are a lot of people who argue the same way. But if we look seriously into the developments that took place within the last 10 days, we'll find that there might be some kind of a different strategy followed by the Iraqis. Number one, Saddam, he went against his parliament. Number two, he shut down his son's paper. Number three, they met the team in a very nice way. Number three, which is yesterday, which is some kind of surprising, they said that they are going to deliver a list of whatever they have before the due date. So how could you look at this? What's your take on this?
I think that's a good question and raises interesting possibilities. I'm skeptical that there will be a genuine response to the Resolution 1441 by Hussein, in the sense that it comes forward with a complete, accurate list of everything which is required by the resolution. I base this conclusion primarily upon the behavior during the 1990s in response to a series of about 10 United Nations Security Council resolutions trying to get the inspection regime to work. And what happened then is that there was really what I think is widely viewed as a strategy of going along with the inspections but trying to thwart the inspections. I read one analysis by one of the inspectors who said that it was like a game. It came to the point where they knew that we knew that they knew that we knew that they knew that we knew that they were not complying. And I think there really was a level, and sometimes that can be an important way of waging politics, which is short of firing guns at each other. I don't mean to be cynical about the importance of going in and having the inspection regime work. One piece of analysis which I've seen which is interesting is that it may be difficult for the Iraqis to make a list with confidence that they think will be able to achieve their obfuscating objectives. Since 1998, there have been no inspections in Iraq, and so the Iraqis may be less confident or less certain of what the United States and others, through their intelligence mechanisms, do and do not know. And this is why I think, from the United States perspective, this resolution is in some ways viewed as a trap for Saddam. Because if he is not sincere, and if the list comes forward in a way that's incomplete, then if the intelligence is such that those inaccuracies are able to be identified conclusively, then it will be very difficult for the international community not to respond in unison to that. If, on the other hand, Saddam has changed, if he has decided that we do not want to pursue a policy of having weapons of mass destruction, if we do not want to pursue a policy of having chemical and nuclear weapons with delivery mechanisms that can reach the United States or at least Israel, if there has been that type of a change, then I think that submitting to the inspection regime will prove very effective for him, because I think it will forestall the need for, and certainly the political legitimacy of, what would then be very much like a unilateral response by the United States. So whether this is very sophisticated and effective strategic or tactical gamesmanship, or whether it really signals a strategic change, I suppose time will tell. I myself personally find it difficult to imagine that there has been a genuine change of heart.
One more question?
Professor Wilkins, follow up on your war powers discussion. Every semester in my foreign policy class, when we get to the point and we're discussing constitutional bases of foreign policy, and the students realize that the United States hasn't declared war since 41, and yet we've fought in Korea, Vietnam, Gulf I, and now maybe Gulf II. They ask me if that constitutional power of Congress to declare war is irrelevant. So that's my question to you. Is it irrelevant, or has it simply been replaced by the joint resolution rather than a declaration of war?
No, I don't think it's irrelevant. I think by the time you have the War Powers Act in 73, there was enough political will saying, hey, we're tired of being ignored and bypassed. The War Powers resolution is not complied with in all of its intricacies. The War Powers Act calls for some sort of authorization. For the last two major conflicts, we have had that authorization. Both times involving Iraq. I doubt, and I didn't tie this up in my remarks, I doubt that should a president 3 years from now, should Bush 3 years from now find it necessary to invade Sudan or something, and we send troops in there, I doubt that 48 hours later, if the president hasn't given a report that Congress is going to demand withdrawal, or that we will in fact withdraw. I think at that point, we're in the same sticky wicket that the Supreme Court found itself in during the Vietnam conflict. I don't want to decide this one. We're in the middle of an ongoing war. And so it's just one of those matters of practical reality. The War Powers Act of 1973 has reinvigorated the importance of the constitutional text. I think what you have now is a reality on the part of the American public, the president and the legislature, that there is a political decision to be made when we exercise war power. For at least a decade now, we have concurrently exercised that power, the legislature and the president. It's not perfect, it's messy, we don't have exact compliance with the War Powers Act, but we have something, I think, approximating the type of political consultation and political process foreseen in the text of the Constitution. That's why I would say, although you can quibble with the details of the War Powers Act, and whichever side you take, you can spit at it. I think by the year 2002, at least for now, we have a regime in the United States where you do have to consult Congress, you do have to get some sort of authorization. So while you could make the argument during Reagan's presidency that Ronald Reagan didn't have to go get authorization anywhere, I don't think you can make that claim as a matter of practical reality today. And I think on the whole it's probably a healthy development.
But nevertheless, the constitutional mandate has not been followed and has not been followed since World War II, which is that we have a requirement written in the text of the Constitution that Congress declare war. And we often talk about this as usurpation of power by the executive branch, but there are actually two interesting sides to the story. And the under-discussed side of the story is the abdication by the legislative branch of responsibility in this area. It has often been found convenient to squawk a little, to duck one's head, and then to place blame if things go badly, and to jump on board and say I was sort of there all along if things go well. And separation of powers doesn't work well if one branch of government has adopted so consistently a policy across generations and across political parties of abdication, which is what the legislative branch has in fact done.
Yeah, I would agree. Just one thing, I think the War Powers Act is a reassertion of power, and while we haven't got back to formal declarations, we're back to something prior to action. And second, even 41 is not a perfect picture, because the president was doing all kinds of things getting ready for World War II, and there's even some evidence that he purposely allowed the attack on Pearl Harbor in order to provoke Congress into acting. And while that question may never be able to be definitively answered, it's not at all clear that that even 1941 was anything other than executive action.
Let's leave that to Oliver Stone.
I'd like to thank our panelists for starting us off with a great beginning. We'd like to take just a 3-minute break, give you a chance to stretch your legs. We're in it for the duration, for a long day of interesting panels. And invite you to also take a look in the foyer throughout the day. We'll have a number of materials available. Borders Books will have a display of noted books on Iraq and the issues that we'll be discussing, as well as vouchers for a discount if you're interested in purchasing something there. We thank you for your attendance this morning and hope you'll stay throughout the day.